Hi, thanks for visiting worklawyer.ca. I'm Jeff Robles, a partner with the law firm of Riley and Partners Professional Corporation in Ajax, and a certified specialist by the Law Society in civil litigation. So, what I wanted to talk about today is the issue of mental distress and how one goes about proving claims for mental injury. Um, in 2017, the Supreme Court of Canada came out with this decision called Saadati and Moorhead. And I wrote about this topic. You can find a couple articles on there on this topic on worklawyer.ca. But more recently, this case was revisited by the Court of Appeal in a decision called Bothwell and London Health Sciences Centre. Now, when it comes to the facts of this case, the plaintiff, Mr. Bothwell, was in the defendant hospital's post anesthesia care unit. And at that time, his blood pressure dropped. There was a doctor attending to him at that time, and the doctor ordered a blood volumizer medication, something that would increase his blood volume, and that medication was called Voluven. However, the nurse who was looking after Mr. Bothwell by mistake administered heparin, which is a blood thinner medication. Now, Mr. Bothwell, by profession, was a paramedic, and upon learning of this mistake, he blacked out. When he regained consciousness, he felt short of breath, he felt very hot. He eventually required sedation and intubation. This whole experience of being administered the wrong medication left him feeling frustrated and angry, as you might imagine. And he later ends up suing the hospital and the nurse for medical negligence. Now, at the trial, the judge found that Mr. Bothwell's psychological upset was both subjectively and objectively serious, and that it constituted a mental injury. The defendants, the nurse and the hospital, they appealed the decision, arguing that the trial judge made an error concluding that Mr. Bothwell's anger over receiving this incorrect medication was not sufficient to prove a mental injury that necessitated compensation. So the Court of Appeal went back to the Saadati and Moorhead decision by the Supreme Court of Canada and reviewed the principles stated by the Supreme Court of Canada. I'm just going to summarize them here. First of all, the mental injury has to be, it isn't proven simply because of psychological upset. It's not enough that you can show that you were upset. Secondly, the plaintiff or the claimant has to be able to show that the disturbance suffered is serious, prolonged, and rises above ordinary annoyances, anxieties, or fears that come with living in civil society. Now, the third element in this test, or the third principle involved, is that it's on the plaintiff or the claimant to show that the mental injury claimed meets that required level or degree of disturbance that I mentioned earlier. The fourth part of the test, the judge or the trier of fact will then consider just how seriously the plaintiff's cognitive functions and participation in daily activities were impaired. The judge will also consider the length of the impairment and the nature and effect of any treatment obtained. And then the last part of the test, the fifth part, is where a psychiatric diagnosis is not available, it's open to the judge or the trier of fact to find or look to other evidence that the plaintiff might put forward to prove on a balance of probabilities that a mental injury has occurred. Now, in the Court of Appeal's decisions, or reasons for its decision rather, the Court of Appeal decided that the judge failed to consider the degree of disturbance that Mr. Bothwell experienced because of his psychological upset. The Court of Appeal also concluded that the trial judge failed to consider the impact of Mr. Bothwell's anger and frustration on his cognitive functions and participation in daily activities, in addition to the absence of any evidence of being treated for those feelings. And in summary, the failure to do so amounted to a reversible error. Now, in reaching this conclusion, the Court of Appeal noted that the appeal record before the court showed no evidence of impairment of cognitive functions or participation in daily life or evidence of medical treatment. To the contrary, rather, the record showed that Mr. Bothwell continued to work as a paramedic and remained a committed father and husband. So very little impact on his daily life. Now, in terms of takeaways for this case, one of the takeaways can be found at paragraph 42 of the reasons of the Court of Appeal, where it stated, quote, "While Saadati makes it clear that expert medical evidence is not necessary to prove medical injury, it also makes clear that where claimants do not adduce relevant medical evidence to assist triers of fact in considering the Saadati factors and other relevant considerations, they run a risk of being found to have fallen short." In paragraph 51 of the reasons, the Court of Appeal concludes that, quote, "Feelings of anger and frustration without more is evidence of psychological upset, not injury." So from an employment law perspective, this decision ties into the Supreme Court of Canada's decision in Honda Canada and Keys, where in that decision, the court stated at paragraph 56, quote, "The normal distress and hurt feelings resulting from dismissal are not compensable." In other words, anger and frustration resulting from a lack of tact or a lack of courtesy by the employer in the manner of dismissal, without more, in and of itself, isn't going to reach the level necessary to prove a compensable mental injury. And so plaintiffs, employees, and their counsel need to think about that. And it would be prudent to keep this in mind when considering advancing a claim for general damages in a wrongful dismissal or a constructive dismissal claim. So that's everything that I wanted to talk about today. If you'd like to get more information about this and other employment-related topics, feel free to visit worklawyer.ca. Thanks very much for visiting, and we'll talk to you on the next one.